I'm Courtney Hansen. I am an attorney at Patterson Law Group, and today I want to talk to you about the demand letter. So you have been in an accident, signed up with our firm, and have completed most, if not all, of your medical treatment required for the injuries you sustained in the loss. You are now at a point where we are going to put together a demand package as well as a demand letter. A demand letter is used to settle a personal injury case. It's usually before filing a lawsuit in court, hopefully in lieu of that. The demand letter explains to the recipient of the letter, which is usually the adverse insurance carrier's adjuster, how the insured is at fault, explains the damages and injuries sustained, and it demands compensation. In the legal profession, drafting a demand letter, a strong demand letter, is somewhat of an art form. It takes good writing skills, attention to detail, knowledge of each injury, and specific knowledge of each client and exactly what they've been through in this loss that really explains the human story of their collision and resulting damages. The demand letter sets the tone for settlement negotiations, which will potentially avoid having to go through with a lawsuit. The demand letter itself sets out all of the damages. It contains medical records and bills, describing the treatment you've undergone, as well as other economic and non-economic losses. Once this is compiled into a nice organized package, it's sent to the insurance carrier with a deadline of typically 2 to 3 weeks for a response to evaluate your damages. So when I say damages, that is a legal term that means money used to compensate injured persons for their losses. Typically in the demand letter context, damages begin with us demanding the entire policy. Minimum in Texas for an auto insurance is $30,000 per person. We either come out demanding the entire policy or an amount that we anticipate being rejected, but is very lofty so that we have room to negotiate something favorable for our client based on everything they've been through. So after 2 to 3 weeks happen, the adjuster will give me a call and she will put a number on what she perceives your damages are. Typically, again, this number comes in very low to begin with, and it's based on ICD codes and fair and reasonable value of medical bills that software programs determine. It oftentimes misses the mark, at least at the onset, on truly what damages the person has been through. So it's our job at PLG to get to this person, this insurance adjuster, and show her who you are and what you have been through so that she can truly see the human story of this loss as opposed to a couple of numbers on a page. Once she has given us an initial settlement offer, I give you a call, talk to you about what that is, and where we want to go with it. We will be discussing all of the settlement numbers as they come in with you, keep you fully informed, and talk to you about outcomes, hopefully without having to litigate, but that is often always an answer as well, if necessary. So the demand package, as you see, is a very important roadmap for the claim itself. It's the last step, hopefully, before settling out your file or before going into a lawsuit to get a more favorable result, if possible. If you have any questions, feel free to give me a call. As I said, I'm Courtney Hansen. I'm the attorney that drafts all of the demand letters, reviews everything before it goes out. Give us a call at PLG. We're here to help you and talk to you about your human story. Thanks so much.